Very good morning to all the participants. Good morning to Principal Sir, Vice Principal Ma'am, Dr. Liji Santosh, Vice Principal Dr. Professor Sandesha Shetty, and to all the team members. We request you all to kindly stand for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उज्जल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जय मंगल नायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Okay, thank you all. Okay, Tushar sir, is the screen visible?
Yes, John.
Yes, John,
Okay.
sir, it is visible.
Okay, a warm welcome to one and all again. Respected Principal Sir, Dr. Sridhara Shetty, Vice Principal Ma'am, Dr. Liji Santosh, who is also the IQAC coordinator of the college, our Vice Principal, Professor Sandesha Shetty, all the team members, and our dear participants. It has been a very testing time for us in this COVID situation, and we are extremely heartfelt condolences to all those who have lost their lives and all those in the hospitals and all those who are in quarantine. So we actually pray for them. So we now start off with the webinar. So a brief introduction about the college. So about Bunts Sangha Mumbai. So Bunts Sangha Mumbai was established in 1927 as a charitable trust, and it is devoted to education, healthcare, and social reforms of downtrodden and underprivileged class of people. So the Sangha has been in the service of people for almost 9 decades. They had initially started off with two schools to cater to the working students, and then they have grown immensely over the past decades. About the S.M.Shetty group of institutions. So, Bunts Sangha's S.M.Shetty group of educational institutions was established in June 1998 in Powai on a plot of land donated by then Sri S.M. Shetty of SM Group of Industries with the initiation of Sri Manmohan Shetty, who is also the major donor. The S.M. Shetty School was inaugurated on 8 June 1998 by Sri S.M. Shetty, our major donor. Today, the institution consists of ground plus 8 upper floors with a total built-up area of 1,35,000 square feet. These are our management members, our profound office bearers. Mr. Padmanava S. Payade, President of Bunts Sangha Mumbai. C.A. Shankar B. Shetty, Chairman Powai Education Committee. Sri B.R. Shetty, Vice Chairman Powai Education Committee. Sri Nityanand Hegde, Vice Chairman Powai Education Committee. Sri Harish Vasu Shetty, Secretary of Powai Education Committee. And C.A. Harish D. Shetty, Treasurer of Powai Education Committee. About our college, so Bunts Sangha's S.M.Shetty College of Science, Commerce and Management Studies was established in 2008 by Bunts Sangha Mumbai. The college is affiliated to the University of Mumbai. It is committed to the promotion and propagation of quality education with excellence. Our vision is personality development for nation building. Our mission to enable young minds to discover and develop their potential in an environment conducive to learning, to create technically competent young individuals with practical skills, to develop socially conscious and morally upright global citizens for a new India. The college offers 6 undergraduate courses and 2 postgraduate courses. We have a PhD center in commerce And we offer various need-based certificate and add-on courses. Some of the awards and recognitions we have acquired over the years: we are a NAC accredited A grade college. We have secured the IMC, that is Indian Merchant Chambers Ramkrishna Bajaj National Quality Certificate of Merit 2019. We have received the Education Excellence Award 2017 from Indus Foundation, New Jersey, USA. We have received the Healthy Workplace Award 2017 by Arogya World, and we are also an ISO 9001 2015 certified institution. Some of our prominent collaborations: we have NUSSD program, which is a national level program collaborated with Tata Institute of Social Sciences. We have collaborated with Lok Nete Venkatrao Hirai College, Nasik, for various faculty development and other courses. We have a collaboration of spoken tutorials with IIT Bombay. We have collaboration with Sri Ambika Yog Kutir for yoga and other required amenities. And we have collaborated with Kotak Education Foundation for the benefit of underprivileged children. These are few glimpses of the infrastructure. We have state-of-the-art IT laboratories. We have a fully air-conditioned multi-purpose auditorium, which also serves as a sports training ground. Then we have a turf-laid playground and a learning resource center, to name a few. These are our organizing committee members. So principal sir, vice principal ma'am. We have vice principal sir. Then we have Tushar sir, who is the coordinator of IT department, and these are the other members. So for any further information or clarification about the college, you can visit our website, which is shown in the link over here. So now we move on to the session. So now I request Principal Sir Dr. Sridhara Shetty to deliver the welcome address and give his introductory remarks. I request Principal Sir to deliver the welcome address and introductory remarks.
I think his mic is muted.
Yes, I also think so. We just check for 1 minute.
A very good morning to all of you. Sorry for the technical glitches in the beginning. I hope you are all safe by the grace of God from this pandemic COVID-19. In fact, we have taken this not as a problem or crisis, but as a challenge and engaged in various academic activities. Our college is going to host a series of webinars in the next 2 weeks, almost on contemporary issues. Therefore, even though we are at home, it is really a value addition in terms of academics. Now coming to today's webinar, Advocate Professor Shaji Sheikh is going to deliver lecture on IPR for the next 1.5 hours. IPR is very, very important and quite significant from even NAC point of view, because almost all the colleges are started with the incubation center, innovations, etc. And all those innovations should be protected through a legal framework. Therefore, IPR is very essential. And if we enlighten our teachers in this respect, and if our teachers take this to the classrooms, and all of this will percolate down to the classroom, so I think our purpose would be served. So in this context, we have kept this webinar on intellectual property rights, and we have invited a highly resourceful advocate, Professor Shaji Sheikh, who has taken a numerous sessions on this particular topic. And he is going to deliver for the next 1.5 hours on this topic. And on behalf of S.M.Shetty College, I extend a warm welcome to him. And nearly 500 teachers across Mumbai, beyond Maharashtra, have registered for this webinar. Keeping in mind the importance of that, I take this opportunity to extend a warm welcome to all the delegates across India. And this would be a quite enriching session at the end of this webinar. At the same time, I extend a cordial welcome to all my vice principals, the BSID coordinators, other teachers who have joined hands to make this webinar a success. Thank you very much.
Thank you, sir. I now invite Dr. Liji Santosh, Vice Principal and IQAC Coordinator of the college, to introduce our resource person, Advocate Sajid Sheikh.
Good morning, everyone present here. It's a pleasant morning. Amidst COVID, we have managed to bring one of the resourceful person available in Mumbai. Mr. Sajid Sheikh is one of the founding faculty of National Law University, Mumbai, and is serving there as Assistant Professor of Law. He obtained his LLM honors, specializing in intellectual property rights from National Law University, Jodhpur, and currently he is pursuing his PhD from Nalsar University of Law, Hyderabad. He teaches intellectual property rights, legal methods, communication and advocacy skills, and legal writing at National Law University, Mumbai. With Center for Civil Society, a leading think tank, he prepared a compendium on repeal of law for the state of Maharashtra, which was submitted to the government. For his achievements in legal field, he was recently interviewed by Super Lawyer, a leading legal portal. The NGO Lawlex is his initiative which effectively works in the field of legal education in India. His valuable contribution to various law journals and informative lectures on intellectual property rights at various workshops organized by Jammu and Kashmir Government, NLSIU Bangalore, Gokhale School of Politics and Economics, IIT Bombay, and other schools are worth recognizing. Dear sir, we are really honored to have you amongst us today, and it is indeed an honor to learn intellectual property rights lessons from you. I wish all the participants an enriching learning experience today. Thank you.
Thank you, ma'am. I now open the session and I invite Advocate Sajid Sheikh, Assistant Professor of Law and Coordinator for Center for Social Research in Intellectual Property, Maharashtra National Law University, to chair the session. Over to you, sir.
Hello. Am I audible?
Yes, sir.
Yeah.
Honorable Principal Dr. Sridhara Shetty ji, Honorable Vice Principals, all the team members, and dear participants, a very good morning to all of you. I could see a huge list of participation from the faculty side, some from the student side, all over India and across Maharashtra. Some of them I definitely was able to recognize also. So I thank you all for joining with us today for this very session on fundamentals of intellectual property right. I'll also be covering some part of research ethics, and we'll discuss about plagiarism and other aspects, because I understand some of the faculty members are also here. So, and of course, be it faculty members or the students, this will be definitely of their interest. So is the PPT visible to all of you right now?
Yes, sir.
Yes, sir.
Yes, sir. Yeah. Visible.
Yes, sir, visible.
As Honorable Principal Sir just said, and I really appreciate the efforts taken by S.M.Shetty College of organizing such webinars and utilizing this very time, the time of pandemic, as an opportunity to reach to the people, and of course to reach to more number of people through online means. So thank you so much for such initiative. When we talk about intellectual property rights or intellectual property, sometimes there is a lot of confusion in our mind. We think that it is something very, very complex, or we think it is something which may not affect us. It may be something which does not matter to us at all. But in this very session, definitely we'll understand as how intellectual property affects us, how it is present everywhere. Just in front of your screens, I have taken one cartoon on which it is mentioned, without copyright law, art would not exist. We have to understand the correlation between the term copyright and art. And again, we'll emphasize this very thing in the session. Next clip talks about without patent law, inventions would not exist. And third one talks about without real estate law, land would not exist. And without marriage law, love would not exist. The first two clips relate to intellectual property rights. But to understand the first two clips, let us think about the third clip, which talks about real estate law. We understand that real estate deals with property matters, development of buildings, and it says if such a law is not there, land would not exist. If marriage law is not there, then love would not exist. It is something which we have to ponder upon. A brief gist of what I'll be discussing, so that we have our goals in our mind. I'll be giving a general introduction to the concept of intellectual property rights. One cautionary remark I would like to make here is that intellectual property rights is a very vast domain. It is not essential for everyone to understand all the nitty-gritties of IPR in the very beginning itself. Our aim today will be to give a basic kind of understanding which everyone should have about the intellectual property rights. And the plan is like this. We'll be talking about why IP should be protected, what are the different kinds of IP, and how we can protect our intellectual property. And lastly, I'll be talking about research ethics, plagiarism, and its relation to intellectual property rights. So before I delve into the conceptual part of intellectual property rights, or what is an intellectual property, I'll just give a very simple example to you. All of us must have certain books with us. We all purchase books. Some are prescribed by our faculty members. Some are available in the library. So what happens if a book has been written by someone and you copy that very content of that very book on your own notebook? What will you gain out of that very copying? And what will the author who has, invested huge amount of labor into that, what will that very person lose? I'll tell you, actually this happened long ago in Babylon Empire, and a unique matter came before the king at that very time. There was a pictographic Bible, in Bible written in the form of pictures. It was created by someone. One very, interesting fellow, what he did not steal that very book. What he did, he just copied that very pictures on his own notebook. And the matter went before the king. At that very time, the concept of intellectual property rights was not that much evolved. So even, everyone was confused. Even the king was also confused as what that very author who has created that very pictographic Bible has lost, and what this very person who has, noted or drawn those very pictures which were available in that very pictographic Bible on his own notebook. Please take note here, he used his own notebook. He used his own pen, he used his own ink, everything was his. And even the person who created that very Bible did not lose anything. Why? Because the possession of that very Bible, that pictographic Bible, remained with that very author himself. But definitely there was a feeling that yes, something of the author has been lost. And from there, the origin of intellectual property rights was there, when they tried to say that yes, there is some intellectual component, some intellectual investment which was done by that very author, which has been stolen, which has been misappropriated by that very person. So that was the very nuanced kind of definition of intellectual property rights. Now let us go a step further. Intellectual property. Let us try to break this very word into two parts. One is the word intellectual and one is the word property. Because I could, find from the list of participants, many of you are not from, most of you are not from, of course, legal background, but you understand what is property. And till date, the understanding of property to us is a physical kind of property. For example, if I'm talking about a book, I'm talking about that, yes, the physical possession of this very book is my physical property. If we talk about land, it is my physical property. If I talk about maybe the mobile phone, it is my physical property. Pen, car, building, everything is my physical property. And this kind of property, which can be touched, which can be measured or has some physical form, is called as tangible property. So we know about tangible property. But now what is intellectual property rights? Intellectual property falls under the domain of intangible property, which cannot be touched. Now you will ask me, sir, you gave an example that book is a tangible property. And again, the discussion which we were having was that the Bible, which was there, how it can be intellectual property, I am here talking about, to answer this very query, that if we are talking about a book, there are two kinds of property involved in this very book. One is the physical property. I purchase this very book from the market. It is my physical property. Nobody can take this very property away from me. Right? This is one thing. But second thing which I am talking about is the intangible property of that very book, which is the content of this very book. To answer this, I'll say, if you have purchased this very book, you do not have the right to issue photocopies of this very book and start selling photocopies of this very book. We all know books published by foreign publication, maybe Oxford publication, Cambridge publication, are very, very costly. Had it been the case that this book, if I purchase, becomes my physical property, I would have started selling, and I would have earned crores of turnover with by selling the photocopy, which is a very less investment, and the kind of market which is there is very high. But I do not have any right over the intellectual content of that very book. Therefore, the intellectual content is the intangible property. So, in nutshell, intellectual property is the creation of mind. It is the property which is protected by the government. The government, grants a certain period of protection of this very intellectual property. Now you will ask me that why intellectual property at all needs to be protected. I will redirect you to the first slide, where I had a few pictures, like without copyright law, art would not exist. Without patent law, inventions would not exist. So this is one aspect. I'll come to this. Some of you may think we are living in a knowledge economy. Everyone talks about free access. Everything should be available to everyone freely. Why are we hindering this very access by unnecessary prohibiting intellectual property by protecting that very intellectual property? A simple meaning I'm saying, again, why I give example of a book, because it is very easy to understand. If I say why we do not get the right to photocopy the books completely, why we do not get right to create our own medicines by copying the chemical formula of very, very costly medicines in the market. You all know there are certain medicines which are very, very costly, and India, which is a generic market, there are medicines which are available at a very cheaper price. Why we cannot just copy such very medicines and produce those very medicines at a large scale? What will happen if intellectual property is not protected? What will happen if this creation of our mind is not protected? I'll briefly discuss. There are certain theories which have been propounded by a lot of various legal scholars, which have given theories on why there is a need to protect intellectual property. One of this very theory is called as the utilitarian theory, which was propounded by Jeremy Bentham. And Jeremy Bentham, what he said that whatever we are creating, should give maximum happiness for maximum number. And what happens when IP is created, when intellectual property is created, people become happy. Why? Because people need that very technology. I'm talking about mobile phone. Mobile phone having the feature of face recognition. You know, now all the latest mobile phones, they have face unlock feature, facial recognition feature. Nowadays, no mobile company will launch a mobile without this very facial recognition software. Right. So this is why, if we want that people should be happy, we should protect the intellectual property. And if we protect the intellectual property, then people, the innovators, will create that very intellectual property, which will lead to greater happiness of greater number. All right. Next theory is the labor theory. And, friends, we will try to relate all these very theories with common examples as and when we will be discussing about the various different types of intellectual property. Next is the labor theory, which was propounded by John Locke. And what he says is that earlier, everything was available freely. There was no proprietary right over anything. Everything in nature was in commons. He has used the term in commons, which means it is free for everyone. Everyone can monopolize it. Everyone can appropriate it. Anyone, whatsoever he wants to do it, he can do whatever with that very resources, natural resources which are available in nature. But he says that if somebody invests his labor upon that very something which is available in the nature, that very thing becomes his property. He gets the right to appropriate that because he has invested his labor into that. Therefore, if something is available in the market, if some free technology is available in the market, or free natural resources available in the market, for example, silicon is available in the market. Silicon can easily be mined. A person creates Intel core processors out of that very silicon, which is available in the market freely. So that chip becomes his property. And that is why, if we are talking about the technology, we are talking about intellectual property, and that intellectual property becomes his, and he needs to be protected for his labor. Third is the personality theory. And this very theory was propounded by Hegel. And what Hegel has said that whenever we create something, we imbibe our personality into that. For example, an artist, a painter, when he paints, he puts in his own emotions, his own talent into that very painting. Right? If somebody is writing a book, he is imbibing, or he's presenting his personality into that very book. And that is why that very creation of his, that is the book, that is the piece of art, work of art, that should be protected. And the last theory is the social planning theory. Social planning theory is very interesting theory. And, again, a lot of legal scholars are there who have somehow contributed to this very theory. One is William Fisher. He says that, intellectual property in a manner governs how a society should function. Now, this is very interesting, that how IP is carving out how the society should function. Here I will give you example. Just think about it. Why do you think at present a lot of innovation is happening in the field of COVID-19, in the field of finding out a vaccine for COVID-19. First example. Second example, why a lot of research investment is being done in the field of finding anti-cancer drug. Why a lot of innovation is happening in the cell phone industry. Nowadays, every other day, you find that a new mobile phone is being launched in the market, having some amazing new functionality. Why? Because the society is in a manner trying to give a direction to the intellectual property, that yes, intellectual property, there is a huge demand of this very intellectual property, and innovation should happen in this very field. And similarly, vice versa, most of the IPs will be created in this very field only. And that is why all these very theories have a link up, that if intellectual property is not created, maybe there will be a kind of gap. There will be kind of gap in the society, because people who want some technology to be there, they won't be able to access that with technology. So coming to this very question of why monopoly versus competition. Now, by discussing all these very theories, we understand that a person has invested his labor. We have come to understand that society is being benefited out of this. Person has invested his personality into it. What is personality? Personality is a part of that very person. So if this kind of intellectual property is not protected, what will happen? Innovations will not happen, because all these very innovations, they require a lot of efforts, and if there is no incentive for these very people, and what is the incentive? The incentive is protection which is granted by the government. If this protection is not granted, then everyone will be free to copy anything, and that is why real inventions will never happen in this very field. Next question comes to our mind is intellectual property right a human right? The answer is yes, it is a human right. And how we can say that it is a human right? If we refer to the Article 27, subclause 2 of Universal Declaration of Human Rights, it says that everyone has the right to the protection of moral and material interests resulting from any scientific, literary, or artistic production of which he is the author. Here, what is the right which is with the inventor? The right is the moral and material interest. Moral means that if I have written a book, nobody else can misappropriately say that XYZ person has written that very book. Everyone has to say that yes, Sajid Sheikh has written this very book. This is my moral right over this very book. And what is the material right? My material right is that I can exploit this very book. I can sell this very book. I can, publish this very book, and I can distribute this very book. Whatever I want to do, I can do with that. And whether there is a mention of intellectual property in the Indian Constitution, the answer is yes. The power has been granted to the Parliament to enact laws related to all the intellectual properties under Article 246, and therefore we have different legislations related to intellectual property rights. So something which is the creation of mind has been categorized into various types of intellectual property. One is the patent. Definitely we'll be discussing all these one by one as we come across those very slides. Patents are for innovations. Innovations, what are innovations? Innovations are technology. Technology is called innovation. innovation is happens on when we create an invention. So patents are granted for inventions. Okay. I'll be definitely discussing about what these patents are in detail. For example, I'll just give an example. For example, drugs are there. For example, technology is there, mobile phone technology, computer chips, the technology behind those very things. So all these are patents. Industrial designs, uh, industrial designs, they protect the aesthetic appearance of anything, aesthetic or ornamental appearance. It will protect, for example, uh, um, there is any toy or something like that that can be protected by a design. Trademarks protect the marks, they protect the brand names. For example, Coca-Cola, Godrej, and so on and so forth. Trade secrets are the secrets which are very much important for a company. So they do not want it to be revealed. So through various means, they try to protect it. Plant varieties are the new types of plants which are bred by various farmers and people in that very industry. Integrated circuits are, I'll give an example here. For example, you have Diwali lights. In Diwali lights, what happened? You'll find out there is a chain of LEDs which is connected to something which is in a black box, and if you've opened it, there will be some chip inside it, a green colored circuit. That is the circuit, and the layout in that very chip will determine how that very LED light will blink. That is the integrated circuit. Geographical indications are the indication which helps us to know from where that very pardon, from where that very product has originated. The example can be Darjeeling tea. Definitely, if you'll think the tea is Darjeeling tea, you'll understand that yes, it is a very good quality tea. And in copyright, all these are called the industrial properties. If you have to categorize it, of course, all these what all I have discussed are standalone different types of intellectual property, and because of the commercial nature of these very properties, they're categorized into industrial properties. And another is the copyright and related rights. Here we discuss about literary work, artistic work, sound recording, musical work, cinematograph films, sculptures, even protection related to softwares, protection related to dramatic work, dramas, which is covered in performing arts. So we'll be discussing all these very things in detail. So in a gist, these are the various types of intellectual property. And in India or in the world, since long there was a wave of harmonization of various intellectual property rights. Why harmonization of intellectual property rights? Because these very rights or IPs, intellectual property, has a lot of commercial value. So and a lot of trade happens with respect to this very intellectual property. If a protection is not available in some other country, nobody will dare to sell his very product in that very other country, right? So various international treaties are there on your screen. You can just have a look. Paris Convention for protection of industrial property, Berne Convention for the protection of literary and artistic work, and other conventions are there. The latest is the agreement related to trade related aspects of intellectual property rights. The aim was of this very treaty was to harmonize the laws. All the member countries which are part of TRIPS, they have to make their domestic laws related to intellectual property similar. Now let us come to the main business which is to understand in detail what these intellectual property rights are. The first one is copyright. Copyright is a legal term describing rights given to creators for their literary and artistic works. What is a literary work? Literary work is the work of literature. For example, I have written something. Something which I have written is the literary work. Artistic work is the work of art. For example, a painting is an artistic work. A sculpture is an artistic work. Maybe clicking a photograph is the photograph in itself is an artistic work. So what is protected under copyright is the original literary, dramatic, musical and artistic work. Please understand here, I'm talking about something which is original, which is not existing earlier. So anything of such nature which is existing earlier, so it can be protected. Do you know that even the movies, the cinematograph films, these are also protected under copyright. Sound recordings are also protected. Sound recordings, if you know do you know that we can record certain musical notes, etc., because we can fixate it or we can describe it in some form. So music, lyrics, all these very things can be protected. Even computer programs are also protected under copyright. Why computer program is protected under copyright? Because there is a huge debate that whether, because in some of the countries, computer program is protected by way of patent law. So in India, we protect it via copyright, because if some of you may have some understanding, all computer programs or softwares are written in the form of code. You may use any kind of software, Python, Java, and definitely Visual, C++, something like that. So you can create the various codes, and the compilation of those very codes, you can create softwares through that. So that work is protected by means of literary work. In India, we can protect a computer program by virtue of patent only in those very cases when that computer software is intrinsically attached to a technology or a machine. Okay, for example, I have created a gaming console. Okay, of course, gaming console, there are certain games into that. What are games? These are certain applications, these are certain computer programs, but I am creating that very program which essentially will work only on that very technology or that very chip or that very computer. Okay, so in that very case, I can definitely patent my that very technology, which along with that will protect also this very computer program. Only in this specific kind of instance, the computer program can be patented. Otherwise, all computer programs, they are protected only via copyright. What is the term? How long it is protected? If you write something today, you will get a period of life plus 60 years. Means till you are living, of course, your work will be protected, plus 60 years after your death. Okay. So this is with respect to literary, dramatic, musical, and artistic work. With respect to other works like cinematographic films, sound recording, etc., you get only 60 years from the date of publication. Now, here something very important I would like to tell you all here is that there is no need to seek any kind of protection for your literary work or the subject matter which is covered under copyright. It is automatically protected. Once you write something, it is automatically protected. Let me tell you, students and dear faculty members, if you are publishing a piece of paper, you are publishing your research, you do not need to go to the IP office to register your work. Automatically, once you have written it, you have your copyright over it, right? And now the question will be, then why people, register this very copyright with the IP office? People register only for a legal proof, because what will happen, for example, I have created a film which is related to something. It's a love story, very specific kind of love story. Somebody else creates that a similar kind of love story. Now, it will be a dispute, because if we talk about cinematograph films, how much of investment is required into that? 100 crore, 200 crore is invested in films. And if somebody, just copies, something like that, of course, it is a huge revenue loss. You must know, recently there was a film. One was Ujra Chaman, and another was of Ayushman Khurrana, related to a similar kind of movie. Was there a lot? This was a legal dispute, which was because both movies were kind of similar as alleged by these very parties. So it is for the legal proof, because if one of the party has registered their copyright earlier, there is no need to show that they created it first or they did something. So this requires a lot of time, efforts are wasted in just proving this. So it is better to seek a copyright if the kind of content which you have created has a lot of monetary value. Now, what copyright protects? All these very things will protect, but one thing we have to understand is that copyright only protects expression. It will not protect the idea. For example, I have in my mind an idea, romantic film. Like we say, two people met, they got married, lived happily ever after. This is an idea. It cannot be protected. But a specific expression of this very idea can be protected. Now, what this expression can be, for example, those very two people, met in London. One was working in IT industry, the other was working in education industry, and some drama happened in their life. They met there, they fell in love in a specific kind of manner. That exact step-by-step expression, that can be protected. That very script can be protected, but only an idea. It's a, a movie based on romance. It is a movie, it's a sci-fi movie based on aliens invading the earth. That is just a fact, my dear friends. Or it is an idea, therefore it cannot be protected at all. Only the expression of this very idea can be protected. So earlier I was talking about when I was trying to define IP as a human right. Because the definition of the Article 27 subclause 2 talks about moral rights and material rights. Whenever we talk about intellectual property rights, again these two aspects are there, moral right and economic rights. So I think this very aspect I have already told you there. Moral rights protect the personality of the author. You know how? I have written a piece. I have written a critique on maybe the education system in India. Okay. So I have what moral rights say that first thing, my name cannot be taken out of that very write up which I have written. Okay. Even I have received remuneration for this very thing. For example, I have written for the Hindu newspaper. They have paid me $100 for my article. Okay, I have received that very remuneration, but they cannot take away my name from that very write-up. That is the moral right. They cannot say, add something on their own. They cannot say that I have also criticized the education system of Harvard Law School. They cannot do that. They cannot distort my work. This is the kind of protection. This is the moral right which I have. Next is the economic right. Now, for example, if I have received remuneration from that very article which I wrote for the Hindu, or it is a kind of a sale which has happened. I have given my rights to the Hindu in return of some money. Now, whatever extra money the Hindu will earn, it will remain with the Hindu newspaper only. Okay. So, the economic right which I had was to receive that very amount. Okay. Now, the owner of that very right is the Hindu. They can also have the right to earn more money. They can put in certain more ads in that very, along with that very right of mine, and definitely they can earn a lot. Just I've given you some examples of all these very kinds of works in literary works, novels, diaries, poems, musical works, symphonies, jazz, improv, uh, choreographic works, dance, ballet, artistic works, paintings, engravings, sculptures. All these are copyrightable. Please take note. Architectural works, buildings, the blueprint of those very buildings, in figurative works, maps, drawings, charts, etc. Cinematographic films, movies, videos, photographic works, and of course computer programs. And who is the owner? If some literary work is there, the author is the owner. Author means somebody who wrote that. Drama, dramatist, music, who was person who has composed that very music. And again, in artistic work, whatever type of that very artistic work is there. For example, painting is the painter, sculpture is the sculptor, an architect in case of building, etc. Similar in cinematograph films, producer is there, sound recording producer is there. Now, one thing we have to understand here. If, and this might be interesting for the faculty members, especially. For example, if we are preparing a reading material for our institution, who will own the copyright over that reading material? Please take note, the copyright over that very reading material will be with the university. Why with the university or that very institution? Because it is a part of your work which you have to do, for which you are being paid by the university. This is the work which you have done in the course of your employment, and therefore the employer, that is the university, becomes the author, becomes the owner. Not author, you will be the author, you will have the moral right. University cannot say, if Sajid Sheikh has written something, university cannot say XYZ has written this reading material after 2 years. It can never say that. My moral rights will remain there forever. But I will not have any monetary right over it. Only my university will have the monetary right over it because it has been created in the course of employment. If, for example, persons are working for newspapers, magazine, etc., those very publishers, sometimes what we do, there are certain publication houses like LexisNexis, Oxford Publication, Cambridge Publication. A lot of journals are there. The various subjects journals are there, and we publish our research there. Now, who owns the copyright over it? Please take note. The ownership of the copyright will remain with the publisher, not with you, until and unless there is a contract to the contrary. Please take note here. Whenever you are publishing something, the publisher will become the owner of your right. You will only have the moral right over it. Okay, but some of the publishers, they have special contracts with you. Certain very reputed publications are there where you get certain royalty whenever your article or your book is purchased by anyone. You get certain amount of royalty, and that is determined by your contract. And sometimes, for example, we pay somebody to, uh, for example, we invited a photographer or a videographer to shoot a wedding, my wedding, for example. Who will have that very copyright? Of course, I will have the copyright because I am the one who is paying the money. For example, I've paid somebody to do a painting, etc., etc. So I have the copyright over it because I am the one paying the. Now, if somebody is delivering lecture, who will have the copyright? Person who is delivering it. If governmental work is there, for example, judgments are there. For example, legislation, bare acts, various reports are published by the government. Who owns the copyright there? Government owns the copyright. And similarly, uh, all these very aspects. Now, if I, for example, if I am guiding my student, okay, a lot of the faculty members, they guide their students. Who will own the copyright here? Here, the copyright will be jointly with the student. If uh, a little bit of guidance is given, it is fine. But if very, for example, if you're talking about a research is being done under supervision of a teacher, then who will own that very copyright? The teacher will own that very copyright. Okay. And if a teacher is, if a teacher writes a book, then who will own a copyright? The copyright will be with teacher because he is employed to teach in that very institute or university and not to write a book. You are not in a university or an institute to write a book. You are there to teach. You are there to create reading material. Okay. So therefore, this is there. You will own the copyright in that very case. In case you are setting a kind of question paper, again, there is a lot of dispute over it. Some say paper setter is the person who is setting that very paper. He owns the copyright. Some say institute owns the copyright. So dilemma is there. If somebody has created encyclopedia or a dictionary, the editor will be the owner of copyright. In case of music, the producer. Now, very briefly, I'll tell you how, because when we said what works can be protected under copyright, we said that original work can be protected. Original literary, musical, dramatic, artistic work, sound recording, musical work, cinematograph, films, computer programs, all these should be original. Now, what is the level of originality which is required? Few doctrines are there. I'll not go deeply into that. First is the sweat of the broad doctrine. It is something very similar to the labor theory. It says that if I have invested my labor, it means I have invested my sweat into something. For example, I went to each and every house of my city. I got the phone numbers of all the people and I compiled it and I publish a telephone directory. The sweat of the broad doctrine, which is not present, which has been rejected now, said that I will have the ownership over even the phone numbers, everything, I'll be the owner. Okay, so this is rejected. Next was modicum of creativity. It said that some minimum amount of creativity should be there. This test also has been rejected, and it says that what is minimum? It means it is setting a kind of a threshold, that this kind of threshold should be there. When only in these very cases we can say that yes, originality is there. This is also uh, rejected. Now what we follow is skill and judgment test. What we say that some kind of creativity should be there. Okay, not minimum creativity, but some kind of creativity. Whatsoever less, whatsoever more level of that very creativity is there, so something should be there. Then we can say that yes, this subject matter is copyrightable. Very some interesting pictures are there in front of you. One is of a monkey. So monkey smiling. From the image you can picture, you can tell that this very monkey has clicked a selfie of his of itself. So this matter went to the court, and the question was whether an animal can own a copyright, because the person himself clicked a selfie. If a human clicks a selfie of himself, of course he will become the owner of his very own photograph. He'll own the copyright over that. But the court rejected it, and it said that animals cannot copyright. They cannot get copyright. And one very interesting picture is there. So here there is an old black and white photo. What a new person did, he just out of this very photograph, he saw this very photograph and created a sculpture, a model. Okay, and the old photograph was not that much popular, but this very sculpture became very popular, and he sold a few sculptures for $3.6 million. And the later party said that this is fair use. Okay, so whether it is fair use or not, we'll try to understand first what is fair use. This is very important for us to understand from an academic perspective what a fair use is, because more or less everyone, be it a student, be it as a faculty, we are engaged in writing assignments to be submitted to our faculty members for our various subjects requirement. And for faculty members, they publish of course research papers, books, etc., to get the API as required by the UGC. So everything we cannot create on our own. We have to refer to something. Okay, and if we refer to something, do we have a right to refer to that very thing? Okay, the answer is yes. We have the right to refer to somebody else's material in a limited manner, and that limited manner is the fair use. For example, somebody has published a book. I can write a critical note of that very book. I can write a criticism or a review of that very book, wherein I may use certain excerpts of that very book. For example, there is a movie which has been released in the market. I have the right to write a review of that very movie, wherein I may disclose to a little bit about maybe a bit of a storyline, why it is a good movie, why it is a bad movie, etc. etc. I can write a news about a technology which has been created or which has been launched in a market. So, just those of you who are from law background here, section 52 of our Corporate Act talks about fair use. Whether a person's use of copyrighted material is fair depends on the circumstances of the case. And this, what is exactly a fair use, what is not a fair use, there is a very thin line difference, and that difference is not clearly spelled out. Till today, in abundance, a lot of litigation happens upon this very the question of fair use. Somebody has used somebody's material without permission, whether it can be used. Some say that yes, because it is fair use, it can be used, and some say no, it is exceeding beyond the limits of fair use. As a faculty and students, uh, so sometimes what happens, as a faculty, we may use certain books and read certain excerpts in the class from that very book. That is totally allowed, because for educational use we are free to use books. Okay. uh, some of you must have heard in the news about Delhi photocopy case. The question, $1 billion question, whether photocopy is allowed or not. I'll not go into the nitty-gritties. What I'll say, limited photocopy for educational purposes allowed. You cannot copy complete book. And the threshold of the standard which is accepted in the market is 10%. Only up to 10% of a book can be copied by you, not more than 10%. And when I say even what is fair use, of course, certain exceptions are given under the law. But again, the threshold is not so clear. Various cases talks about fair use. A use can be called as fair only when there is a need, that a concept cannot be explained without the use of that very material. I'll just give you an example. There was a case of Super Cassette Industries versus Hamar Television. Okay, wherein na Tare Zameen Pe. Tare Zameen Pe song, of course, it's a movie also. The song is Ma. You can very easily recognize that very music, and you can say that yes, this music is from Tare Zameen Par. So what had happened, Super Cassette Industries owns the copyright over this very music of Tare Zameen Par and the music of Ma. What Hamar TV they did, they used a 10-second clip of Ma song in one of their documentaries without seeking license from Super Cassette Industries, and it was considered infringement. You know why it was considered infringement? It was said that Hamar TV failed to establish that there was an actual need to use that very sound clipping to describe or to present their documentary. The documentary was on child labor or something like that. So something very small can be very substantial. Out of a 5-minute song, 10 seconds is very limited, but that 10-second can be very substantial, that can be the essence of that very whole song. If you just play that very small audio of that very beginning, the chorus or something, what we say, we can recall that very song. Similarly, from an academic point of view, limited amount of copying is allowed, and whenever we are copying something, we should cite that. We should not appropriate that it is mine. We should always cite whatever we are using. And in this regard, I'll talk about a bit later in my presentation, which is discussing about UGC norms, plagiarism, so on and so forth. I'll be discussing that part there. Now let us jump to the next kind of intellectual property, trademark. If I tell you what is the best mobile phone brand which is available in the market, most of you will no doubt say Apple. Some may even be courteous enough to say, and they'll say Samsung. Some will say Xiaomi. Some will say Samsung, so on and so forth. So what is a trademark? A trademark is a mark which distinguishes goods or service of one person from the goods or services of another person. For example, Apple, you know what type of mobile phones are created by Apple, what kind of laptops, tabs and other things are created by Apple, Samsung, so on and so forth. If for example, you go to market and you want to purchase a Maggi kind of thing, some noodles, you will always look for, renowned brands. Okay. Some food product, you will go for PepsiCo. If you want to have a drink, you'll go for Coca-Cola, maybe Thumbs Up. If we say Google, Google is one of the best sites to do fast research. Okay, if you want to sell or purchase something from the e-market, you'll go to Flipkart, you'll go to Amazon. So all these very things, when we are thinking about all these very things, we are thinking about certain marks which are associated with certain goods. Goods as in Apple phone, iPhone, MacBook, Note, Samsung Note, etc. All these goods and services are attached with a mark. And that very mark distinguishes goods of one brand from the another brand. And that very mark, my friends, is called as a trademark. Why trademark protection of trademark is very important. Trademark protection of trademark is important because a goodwill is attached in the market to that very trademark. If I say Apple phone, you will 100% say, yes, phone will be good. For example, tomorrow Apple launches a new phone. A horse race will start and people will start, going and purchasing that very new phone. Why? Because people know Apple is a very reputed brand. Facebook, or all these very things are very reputed brands. For example, Facebook. If why people log in and create their accounts on Facebook? Because people know that yes, their data sharing policy is well acceptable, is well within the acceptable limits, and their data will not be shared, and photographs, etc. They'll not be shared, and kind of we use WhatsApp for even private conversation, because a kind of a goodwill is attached to that in the market. We know that yes, on WhatsApp there is an end-to-end encryption. My data cannot be revealed to the outside world just like that. So this kind of goodwill, a kind of distinctiveness is being achieved by the help of trademark, and the protection of trademark is initially for a period of 10 years, which can be renewed again and again. Again, I would like to mention here is that there is no need to protect or register your trademark. Okay, but you can register your trademark, because if you do not register for trademark, you can, if somebody uses your trademark, you can sue them for passing off. But if you register a trademark, if somebody else uses that very trademark of yours, you can sue them for infringement. The punishment for trademark infringement is more stringent, and again, you have a proof that yes, you were the first person to use that very trademark from the legal point of view, because just think about the annual turnovers of all these very big brands, the images, the logos which you see in front of your screen. The turnover is huge, and if they are not protecting and somebody else uses it, and then again they'll enter into a huge loss. So it is always advisable to register your trademark. So what can a trademark be, or be like? It can be a sign, words, letters, numbers. A sign, Nike brand, there is a tick mark kind of thing. Words, anything, IBM computers, IBM. Letters, anything, numbers, 8 p.m. soda can be there. Drawings, pictures, emblems, etc. Some logos are there, some drawings are there. Colors, combination of colors are there. Shape of goods, Jaguar. The Jaguar has a shape mark also. That Puma, which is the even Puma shoes. So the Jaguar logo is in a 3D form also. So all these very things can be protected. And Apple, the Apple kind of a mark is there for Apple. Now, these are the various trademarks which you have discussed, but there are certain trademarks which are evolving. Okay, there are motion trademarks. Just a second. I'm just trying to play. This is the example of a 3D mark, motion. Oh, sorry, a motion trademark. So this is a motion trademark. And Doordarshan, Doordarshan TV, there is a kind of a graphic which comes up, and it places itself in the form of a circle. That is the motion trademark. 20th Century Fox, some lights. 20th Century Fox is written, and there is a kind of light coming from behind. So that is the motion trademark. Personality marks are there. Again, one thing is that SRK, Shah Rukh Khan, SRT, Sachin, Ramesh Tendulkar, Amitabh Bachchan and all. One thing is that these are registered as trademarks in a sense. But again, there was a case wherein, case of a gutka, wherein Amitabh Bachchan baritone voice was copied, and it was seen to show that Amitabh Bachchan is advertising a gutka brand. Okay, so there the court, though they are not formally registrable, these personality marks are not formally registrable, but under the right to privacy, they can be protected. In some countries, they can be registered, of course, but not in India. So the court there said that Amitabh Bachchan has a right to privacy. He has his own personality, which he can protect from distortion. So smell marks are there. In India, smell mark is not protected. It can be protected, for example, if it is associated with a good which is not uh, directly related to that very smell. For example, if there is a Chanel perfume, you cannot, trademark that very smell of Chanel, though in some countries it is protected. What you can do, for example, there is a kind of a smell which is there in a rubber tire. You can protect that. Why? Because the smell is not directly associated with the tire. By what I'm saying is that tire has some other function. Okay, tire is a tire used for maybe motor cars or something. Only smell part is associated with that. But we are trying to sell the trademark, which is in itself a smell. So that cannot be done. Taste marks are there. So it is a developing kind of thing. Sound marks are there. Small jingles, uh, the Nokia tone. So all these very things are there. When I talk a personality mark, you must have seen there's a photo of Usain Bolt in the world. So he has trademarked his kind of expression. So this is owned by Usain Bolt. Coming to geographical indications, just to the organizers, how much time do I have? Hello?
Hello, sir. You have still 20 minutes, sir.
Okay, fine. Not an issue. Thank you. So, geographical indications. Geographical indications are signs used on goods to have a specific geographical origin and possesses qualities or reputation that are due to that place of origin. Agricultural products typically have qualities that they derive from the place of production and are influenced by specific local factors such as climate and soil. Why geographical indication is very important protection? It is a kind of a community right. It is a perpetual right. Forever it remains. For example, the people know that tea which is produced in Darjeeling is having a very different kind of aroma. It is of a very high quality. So a quality is associated with that very geographical region or origin, right? Take an example of Kashmir Pashmina or Mysore silk. People know that yes, the silk of that very area is of very high quality. And now even Tirupati Laddu, uh, which is offered as prasada at Tirupati, is also a geographical indication. So, people from this, if we use a GI tag along with uh, a trademark, how these are used. I'll give a real example. You must have purchased Taj Mahal tea. Okay, on Taj Mahal tea box there will be written Darjeeling tea, Assam tea. Okay, so what is Taj Mahal? Taj Mahal tea is a trademark, and Darjeeling tea is a geographical indication. We call it as GI tag. Okay, and people, what will happen to due to this? People will buy more and more of that very Darjeeling tea. Industrial design, very interesting. I was telling you earlier that industrial designs, what they protect the ornamental or aesthetic appearance, how a product looks. So it only protects looks. Okay, it is valid for 10 years, which can be extended for 5 more years. Okay, uh, I have just an example of a Tata Nano car. Various components are there. All these very components, they have a separate design. For example, the headlight has a design, bonnet has a design, the windshield has a design, the spoilers, the side mirrors, everything. There are 37 designs which have been registered within this very whole Tata Nano. Nobody will register the whole Tata Nano as a one design. Okay, they have registered as a separate design. Also, design for a pen can be there, design for a vase can be there, design for a scissor, bag, etc. Anything can be there. Industrial design, we say that it can be manufactured in an in through an industrial or mechanical process. For example, if I am able to create, if I'm creating something by hand, I cannot seek a design protection over it. I can seek only design protection over it if that can be reproduced through a mechanical process. For example, I have created a sculpture which I am putting in a mold, and I am through a manufacturing process, I am creating more numbers of it. So in that very sense, industrial design can be registered and protected. Again, it is a very it's a right totally of a commercial nature. Semiconductor integrated circuit layout designs are also there. I have told you about these. Certain chips are there. The placement of those very chips will alter the functionality and how those very transistors, resistors, semiconductor, etc. transistors are placed on that very, we can say, on a circuit, on a motherboard. If you have opened your mobile phone, somebody who has broken their mobile phone, you will see a green kind of board inside your mobile phone. If you have opened your computer PC, you have seen, a green kind of board is there on which certain placements of these very transistors, resistors, etc. are there, chips, etc. are there. This layout is protected by Semiconductor Integrated Circuit Layout Design Act. Registration is valid for a period of 10 years. Lastly, very important intellectual property, which is the patent. And in the beginning, I told you, a patent is an exclusive right which you get over an invention which is created by you, and the protection you get is from the government for a limited period of time, and the protection is for a 20 years period. You are getting a protection, and in return of that, you have to mandatorily disclose your invention to the public. Right? And you are disclosing your invention to the public, and in return, the government is guaranteeing you that yes, you will have your IP right or a patent right protected. Nobody else can make, use, manufacture, or market this very invention which you have created. So patents, they recognize the creativity, and it helps to incentivize and encourage the innovation. I was telling you uh, that in the beginning we were discussing about justification of intellectual property and how those very theories are really can be applied to understand the real IP. I said because if incentive will not be there, if incentive will not be there, then people will not innovate at all. Right? Just a small example I've given here. Why drugs are very costly? Because there's a group of people who talk about that there should be an unlimited kind of access to medicines. You know, in India, there are people who cannot afford drugs because, and some of the drugs, the course of that very drug, you know, costs around 1 lakh, 2 lakh rupees per month. Very, very costly. It is not affordable at all. Okay. So now the point is, you know, why there should be access to medicines and why access to medicines should not be there, or you know, should we try to balance it out, balance these very rights of creator versus the consumer. A small uh, flow chart is there towards the right hand side of your screen. When I said that for a period of 20 years you will get protection over your drug or over your invention, please understand that, for example, there are 5,000 to 10,000 compounds which are created, and upon these very drugs, tests are done for a period of 3, 4, 5 to 6 years, and then preclinical trials are done, then clinical trials are done, a lot of investment happens, and then approval of the in India drug controller approves the drugs. In US, FDA approves those very drugs. So all this very time period, around around 10 to 12 to 15 years are just wasted from creating a drug and having a stable form of that very drug. A lot of research and investment happens in those very drugs. Billions of dollars are invested in order to create one drug, and therefore, if you know, we give a free access to medicines to all, if we do not have a limited monopoly, what will happen? No innovation will happen. Now, I'll tell you one thing. In India, we say that we are a generic market. In India, very limited innovation happens. Whenever there is a drug whose patent term is expired, what we do, we are a huge generic giant. We do uh, reverse engineering of that very drug, and we create that very drug. Okay, so uh, in this very manner, we can say that yes, if protection is not granted for patents, what will happen? Research and innovation will not happen. Next, very important thing which we should know about patents is that there are 3-step criteria by which we can protect our patents. So here, I would like to emphasize over those very students who are from engineering background, who create technology, who create some kind of machines, who do some kind of innovation, be it a frugal innovation. So how you can protect it, and uh, whether can you protect your invention or not. So 3-step criteria as per our Indian laws under which you can protect your patent is, firstly, it should be novel. It should be new. That invention which you are doing should be new. It should not be existing earlier. This is number one. Number second is there should be an inventive step involved into that. When we say inventive step, it means it should not be obvious. Okay. Means, for example, uh, for example, I have created a a bottle to store juice, that very bottle can also be used to store maybe milk also. So it is very obvious that, it can be used for some other purposes also. I can use this very bottle and can as a storage device also. I can put some chemical into it. I can attach that very bottle with some machine. So this is something which is obvious. So if I am seeking protection, patent protection, that very invention should not be obvious. Third is that there should be some kind of utility attached to it. Okay, it means it should be useful. Maybe it is less useful, maybe it is more useful, but there should be a little bit utility attached to it. Now, when we talk about again inventions, we say that invention should be workable. For example, I say I have a theoretical concept of creating a time machine. I only on paper it is there. Theoretical concept is there. Actually, I'm not able to make it. It cannot be protected because it falls under the subject matter which cannot protect it. Again, if there is a pen and there is a torch, I attach pen and torch together. I say new pen, I can write in the dark also. It cannot be protected at all. Why it cannot be protected? Because it is only a kind of aggregation of the properties. It's a kind of admixture. It is just addition of two properties of already patented or known substances. Therefore, it cannot be protected. Therefore, if you want to protect your technology, you should try and find answer to these three questions. The first question is whether your invention is novel, whether your invention is new. Second is whether it is so obvious, whether anyone can just think about it, right? For example, there is a DTSI engine. Okay, DTSI engine used in motorbikes. What I do, even a mechanic can do. What he does, he reduces the size of the pipe which transfers the fuel. And I say, okay, I have created a new technology which uses less fuel. What is this? This is not this is not fulfilling the criteria of an inventive step because it is very, very obvious, right? So this second question, you should try to find an answer. And the third question is whether it is useful, whether it has any kind of industrial application. And when I say industrial application, I mean that whether it can be created again and again. If I can create a drug, I do an experiment which can happen only once, the experiment which I can never recreate, so that can never be protected. I should be able to get a static result again and again, again and again. I should be able to create such a technology which should give a similar kind of result. Okay, so if these three questions, the answer is that yes, it is novel, yes, it is non-obvious, yes, it is having a utility, I can think about seeking protection to these. In the last part, I'll discuss about how we can protect it. The last, I think, yeah. So the last intellectual property is trade secret. Let me tell you, there is no law to protect trade secret. It is considered as an intellectual property. Why? Because secret is something which has a very high economic value for a person who is the owner of that very secret. The example is Coca-Cola. We cannot protect it via patent, trademark, this industrial design, nothing like that. I am talking about not the brand name Coca-Cola. I am talking about the composition of Coca-Cola soft drink. Till date, it is more than 100-year-old drink. Till date, only 2 people know about how exactly is Coca-Cola made, or what is the combination, in what quantity substances have to be added in order to attain that very taste of Coca-Cola. And what they do, there are 2 people, they never travel together, because if they travel together, what happens if they meet some disaster or they die? Okay, so they travel separately. And normally, if some of you have interned with some technology companies, maybe software companies or things like that, even law firms also, they ask you to sign a non-disclosure form, or they ask you to give a non-disclosure certificate, which means that whatever you'll know there, whatever work you will engage yourself into, you will not be able to, you will not disclose that very thing with anyone. Okay, so trade secret is protected in India through contracts only between employer employee. They have a special kind of contract that yes, they will not reveal this very secret with anyone. In this very manner, business secrets are there, some kind of how to trade, how they are attaining profits, all these very things, though they are not protected under any other kind of intellectual property, but remain a secret. So there is no there is no positive protection which is granted. Okay, it is only a negative kind of protection, that by virtue of that very contract, the other party who is privy to that very trade secret will not disclose that very trade secrets. Now, when we talk about a product, okay, we go to a market. I have in front of you a shoe of a brand named Nike. When we talk about a product, it is not that only one IP is associated with that very product. There are multiple IPs which are associated with that very product. Patents, for example, for this very shoe, patents are there which protects the technology which is used to develop that very shoe. Maybe the technology is with the foam. It gives you a very different kind of comfort. Maybe it has a very better kind of grip. That is the technology. Design, how it looks. Trademark, the Nike brand itself, the logo itself. Copyright will protect. Maybe the kind of images are used on this very shoes, or maybe all these very products, they have different manuals and advertisements, banners, etc. So all these very things are protected. Again, and one more example I want to give you is of a mobile phone. Mobile phone has the technology which is associated, the chips, etc., are patented. The how this very mobile phone looks is protected by virtue of design. The applications in this, or the games applications in this very mobile phones, are protected via copyright. Okay, and the mobile phone, the brand name, is protected by virtue of trademark. So I'll take only maximum 5-7 minutes. I'll be talking here about my last part of my presentation, which is on research ethics, academic integrity, and plagiarism. And it is important for every one of us, all of us, to understand, be it a student or be it as a faculty, to understand what is academic integrity and what is plagiarism. And I have narrowed down the understanding of plagiarism to the prescribed guidelines which have been given by the University Grants Commission. Because for us, we always want certain parameters to be there, certain quantification to be there, which will make us understand this very concept better. Plagiarism in simple terms means misappropriating somebody else's work as your own. I will repeat again. Misappropriating somebody else's work as your own. In a research paper or in an assignment, I take 2 paragraphs from a book, I paste it there. I do not cite from where I have taken those very 2 paragraphs, and I start writing 3rd paragraph of my own, 4th paragraph of my own. What is a kind of impression which a reader is getting? Reader will think that, okay, these 2 paragraphs also has been written by this very author. Okay, so in this very manner, what are you doing? You are saying, this is mine. Actually, it is not yours, it is somebody else's, which you are saying it is yours. This is plagiarism. Copying without due citation, copying without permission is plagiarism, and which is totally against our academic ethics. Before I go into the quantification part, I would like to tell you all that recently UGC gave out a notification regarding self-plagiarism. Earlier, you must be thinking that if I have written one research paper, I am free to use 3 paragraphs, 4 paragraphs of those very research paper and publish a new research paper out of that. Or people who must have written thesis or PhDs, what they must have may think that, okay, I'll take one chapter and I'll convert that very chapter into a research paper. Let me tell you, friends, that this is prohibited by the University Grants Commission under the term self-plagiarism. What it means that text recycling or self-plagiarism, it includes republishing the same paper which already has been published elsewhere without and full citation, and publishing smaller or excerpted work from a longer or previous one without due and full citation. Of course, you can use 2 paragraphs, 3 paragraphs from your own earlier work, but you have to cite that thing. You have to mention that you have taken these 3 paragraphs which you had already published earlier, in this and so journal or so and so book. Then it won't be plagiarism. Why? Because you are citing it. You are telling that yes, this is the source. And again, if you must have done some sample survey, some study, okay, and you are taking that very study and writing a new paper, or taking a part of that very study without citing, without mentioning that this study you did for that very research paper which is already published, okay, or which is about to be published. Please take note. For example, if I have submitted a research paper in 1-to-1 publication and it has been accepted and it is to be published, I publish a similar paper elsewhere. This I cannot do. Okay, because if I have communicated something for publication, again, if I'm reusing that very thing, that will also amount to self-plagiarism. And even please take note, if you're paraphrasing your own work or somebody else's work without due citation, if you are doing your paraphrasing your own work without citation, it is self-plagiarism. And if you're paraphrasing somebody else's work without citation, it is plagiarism, normal plagiarism. So with respect to plagiarism, what repercussions you can face as a faculty? You can lose promotions, and there is an onus on the vice chancellors, the deans, the directors, um, to find out in interviews or in promotions that the person or the applicant has not or is not guilty of self plagiarism. UGC is yet to give out a detailed parameter on this very thing, as what exactly will be the self plagiarism, what is the standards of self plagiarism, which will be, they'll notify very soon. I'll request your attention to the UGC Promotion of Academic Integrity and Prevention of Plagiarism in Higher Educational Institutions Regulations of 2018. So we all know that if there is a similarity, it means there is plagiarism. Similarity without citation is plagiarism. Now, what is excluded? Here I would like to just mention, there are softwares like Turnitin, softwares like Orkun. They only check the similarity. They'll not check what plagiarism is, what is the quantity of plagiarism. Only a guide or a faculty is reading the plagiarism report of or similarity report of his or her student. Only that very faculty can find out what is the similarity which amounts to plagiarism or what does not amount to plagiarism. So because the softwares will tell that every, even if you are quoting something, they'll say it is similarity. If you are not quoting, it is similarity. So everything is similar to these very softwares. So that is why in those very softwares you have these very option to tick and untick what all content you want in your plagiarism report. All right. So what does not mean similarity or what is not plagiarism is all quoted work reproduced with all necessary permission and or attribution. If you're quoting it, very good. If all references, bibliography, table of content, preface and acknowledgements. So all these very things, if you are mentioning in your research paper, mentioning in your thesis, mentioning in your PhD, it won't be taken into the similarity check. All generic terms, laws, standards, symbols, standard equations. For example, to the law students and others, those who have joined, if we are copying one section and pasting it there to explain that very section, that does not mean plagiarism. If we are taking some excerpts from a judgment, but we have to mention there that we have taken this from this very judgment, we are mentioning this very section of this very legislation, it will not amount to plagiarism. And similarly to others, if we are using some paragraphs, paragraph or something from previously published work, and we are quoting that very thing, of course, it is not to be considered as plagiarism. But again, various law journals, in order to maintain academic integrity and ethics, what they say that only 20% similarity will be accepted. 20% similarity, it will include everything: case law, legislation, report, books, journals, everything. So not more than 20% content you can copy, be it with citing, be it without citing. Not more than 20% you can recreate or copy paste. Okay. Normally, to our understanding, earlier it was 30 words, but now, if there are 14 words, 14 consecutive words, without any citation, it will not be considered as plagiarism. Okay, for UGC. But if beyond 14 words, if they are unquoted, if they are not cited, then it will amount to plagiarism. All academic institutions, they have to form up an institutional academic integrity panel, and certain penalties are there if, and it is given under various levels. Similarities, if it is up to 10%, it is level 0, no penalty is there. If it is 10% to 40% similarity, level 1 is there, and such a student will be asked to submit a revised script within 6 months time. Then if it is from 40% to 60%, then it is a level 2 plagiarism, and such a student will be debarred from submitting a revised script for a period of 1 year. It means that for 1 year, 1 year is wasted. You need to submit your thesis, your dissertation after 1 year. Level 3 is beyond 60 years. Such student registration for that very program shall be cancelled. So game over here. So your registration will be cancelled. And again, if, for example, level 1 is there, person again commits level 1 level 1 plagiarism, then for the second one he'll be charged with level 2 plagiarisms, and so on and so forth. And this has to be assessed and analyzed by the institutional academic integrity panel. For again research, publications, etc., level 0 is up to 10%. Nothing will be there. 10% to 40%. Person shall be asked to withdraw the manuscript, and he may ask, this is for the faculty members I'm saying. So level 1 may your manuscript will be withdrawn and you'll be asked to resubmit after making changes. If level 2 is there, then you'll be asked to withdraw the manuscript, and you'll be denied right to 1 annual increment. You'll not be allowed to supervise any master's, MPhil, PhD scholar for a period of 2 years. Again, a very big risk for faculty members. Level 3 is similarity is above 60%. Withdrawal of manuscript will be there. 2 successive annual increments will be denied. And again, you will not be allowed to supervise any of these candidates for a period of 3 years. And if repeated plagiarism is there, one higher level of punishment is there. If level 3, it means more than 60% plagiarism is there more than once, then you can be suspended from your services. So with this, we come to an end of my presentation. I have only 3 slides, which will only take 3 minutes. Before this, I'll talk about where to register your intellectual property. Before where to register, why is intellectual property important for us? This is for your self-reading. Okay, just think about it. Just read it as an individual, because everyone said that knowledge of intellectual property is very important. Why it is important for us? Why, if I'm not aware about the concept of intellectual property, what all losses will be there? Again, from all the very types of intellectual properties, we came to know that yes, if intellectual property is a great monetizing tool in our hand. Small softwares are sold for crores of rupees. Algorithms are sold for crores of rupees. Movies are created for crores of rupees. the scripts of a movie is sold for millions of rupees. By singing a song and by monetizing that very song on YouTube, you can earn thousands of dollars. Okay, and by publication, again, you can earn a lot of royalty. Some of you must be earning a lot of royalty from your already published material also right now. Okay, so a lot of these things you can do, and if you create a technology, then, and if you are able to seek a patent protection over that very technology, then sky is the limit. And let me tell you one thing, friends. Sometimes innovations happen just like that. As an experiment it happens, or by chance it happens. Okay, so you should know that how to protect your intellectual property. The registering authority of IP, that is patent, design, trademark, and geographical indicator, is the Controller General of Patent, Design, Trademark, and GI. You can visit ipindia.nic.in. Nowadays, you can file your intellectual property online also, but only those very parameters which I told you, you should know, which you should consider before registering your intellectual property. For patent, 3 steps: novelty, inventive step, and utility. For trademark, you should know that whether it is capable of distinguishing goods of one person from the another, or it is deceptive. If it is deceptive, then it cannot be registered. For example, I was reading a case, legal news earlier. Fruity is there. There was one brand name, FROOOOTI. What is it? It is deceptive mark. It cannot be registered. I cannot register APPPLE for a mobile phone. Why? Because it is deceptive. If it is registered, it will hurt the goodwill of Apple. So the test for trademark is that it should not be deceptive. It should be able to be represented in a graphical format. It should be, I told you, why smell mark cannot be, of course, now smell mark cannot be registered as a trademark, because it is very difficult to clearly describe the smell. Okay, and whereas other marks like image, which is called as device mark, word mark, alphabet, letter, etc., it can be described, it can be mentioned, depicted. So that is the test for design. I told you it protects aesthetic appearance, ornamental aspects, it protects, and copyright, the work should be original. Okay, so these are the tests. So ipindia.nic.in, all these very IPs, you can find. There is a process of e-filing also. You have to pay certain amount of fee along with that. With respect to patent, design, trademark, all these, you need certain external help to file all these very applications. Or nowadays, MHRD, by through its various departments, one department is a department of promotion of industry and internal trade. They have set up a lot of IP facilitation centers in various universities, institutes. Our university, Maharashtra National University, Mumbai, we also have a chair, IP chair, and a facilitation center, which is sponsored by this very department. So you can also contact us if you need help in registration of your intellectual property. There are 2 other websites for corporate.gov.in. There you can register. And for semiconductor and IC, you can register this very website, which is on your screen. Certain more resources, if you want to know more about IP, of course, the official website of IP India, you can register, you can visit, and you can know about it. WIPO, World Intellectual Property Organization. This is an international uh, international organization which deals with IP rights, IP rules, regulations, and administration of these rules. You can know more about the international regime on WIPO website. You can, and now one question will be in front of you: how to know if something is already existing earlier or not? So in these very websites, you can search for earlier existing trademarks, you can search for earlier existing patents, earlier existing designs, geographical indications, etc. So these resources you can use. I myself run one legal news and opportunity website, lawlex.org. So you can visit that also to get some legal knowledge. So last three slides in front of you, my dear friends. I'll be monitoring this very chat also. You can reply in chat. This is a question in front of you. Which of these are inventions? One is a cloud. We are talking about rain cloud. There is a car. There is a video game. There is a fossil. Fossil is like coal, crude oil, etc. There is an alarm clock. Which one of these is invention? Take around a few seconds and try to answer. Friends, just give a try. Just give a try. I want a few responses. Yes, a few of you are responding. Which of these do you think is an invention? You all know that only inventions can be patented, because the definition, the legal definition which is given in the Patent Act, says that patents are given to inventions. Okay, so few responses we have. So doesn't matter right or wrong, but at least like we all should participate in such things. Cloud is something which is naturally existing. We have not done anything. We have not invested any kind of labor. It is not an invention. A car of course is an invention, but of course it's not like the whole car as a whole is protected, but the various components will be protected. Maybe the circuitry will be protected in a different manner, engine will be protected in a different manner, maybe the fuel dispensation system will be protected in a different manner. Next is video game. So video game in India, it is not protected. Okay, it can, I told you, it can be protected only if a video game is associated with a technology. For example, there is a console which is attached to a video game, only then it can be protected. Otherwise, be it video game, be it a mobile app, be it a PC app, all apps are essentially softwares. It is protected only under copyright. Fossils are naturally occurring substances, cannot be protected. Yes, alarm clock can be protected. Okay, hope I have given you the answer here. Next question is, find the famous trademarks. It is a Sudoku kind of thing. Please, friends, respond as soon as possible. Just combine any letters horizontally, vertically, diagonally, and just post your responses. Come on, come on. Can we find any trademark here, any brand name here which you know of? Do you know any brand name? Try to find out. Wow, we have received one answer. Amul. Okay, very good. Very good. Let me, on the left hand side from top to bottom, let's go. PEPSA, Pepsi. Right. So a lot of, in this very Sudoku kind of thing, a lot of brand names are here. Amul, Pepsi. There is Tata. On the second line, there is Tata. There is Horlicks on the fourth column, so on and so forth. Very good. Thank you everyone for your responses. Now let us. Okay. So thank you everyone for listening to me. I hope some of your doubts have been cleared here. Though some have, asked certain questions here. Let me see. Please guide on full-time IPR courses and name of institutions. Okay. Again, it depends. There are some of the IP courses are only meant for law students, but if you're not a law student, then there are certain diplomas which you can do. IGNOU offers many diplomas. There are various websites which offers free and paid courses on IPR. There is a Coursera, edX, you can visit there, and definitely you can visit. One question is there, what is a difference?
Sir, Sajid sir.
Yes, sir.
We are taking a poll. We will take a poll and then you can continue with QA. John sir and Vinay Shapurkar sir will help you to read out the questions.
Okay.
So that if any remaining question that we can address. So all the participants, good afternoon to you all. Myself, Dr. Tushar Sambare. We are going to take a poll. So requesting you to answer that poll in next 30 seconds or 40 seconds you can take. So I think everybody is getting a poll on their screen.
Created a mobile game.
Yes,
You
yes,
can
it is
protect
there on my screen.
Requesting all participants to please solve the poll. There are few questions. I think few of them have not heard. There is a poll in front of your screen. Everyone has to answer the questions. In between that, John sir and Vinay sir, can you just go through questions and keep it ready for Sajid sir. Sajid sir will answer.
No problem, sir. We'll do that.
Sajid sir, we have shortlisted the questions. Actually, there are many questions.
Yeah.
So there are some which we feel are very much relatable and important. All are relatable and important, but I think due to time constraints, some have to go to another webinar. So there are some things which we can take. And is it okay if those which are unanswered, the participants can mail you the questions?
Yes, of course. Of course. In the last slide, I displayed my.
Yes, sir. I don't know whether they have taken it down or no. So we will share it in the group again.
Yes. Okay.
And regarding the PPT also, we will discuss it with you, whether we can share it or not later on.
Yes. Yes.
Okay, so one of
Still
the
waiting,
questions.
sir. John, sir.
Yes, sir.
More few seconds we will wait. Let us end the poll first. Requesting all participants to finish the poll as early as possible. Till now, 180 participants have responded. Just give us a 10 seconds, sir. People are answering the poll.
Okay, sir.
No problem. John sir, can you enable my video?
Yes.
Yes, sir.
There are 208 participants yet replied, and people are also seriously replying to that one. Second by second, it is increasing. Okay, in next 10 seconds, we are ending the poll. In next 10 seconds, we are ending the poll. Participant, please listen. In next 10 seconds, we are ending the poll. Okay, we have ended the poll. We have ended the poll.
Okay, sir.
These are the results. Okay. Okay, sir. John, sir, you can take control and you can start with QA session.
Okay, I think sir, Sajid sir can share some light on the questions, so then we can go with the
Yeah.
question answer
Yes.
on the poll questions.
Right. So, first of all, for the first question, I'm very happy to know that maximum participants chose the right answer. Mobile phone game is a software. So softwares are protected by under copyright law. So they can be copyrighted. The answer is copyright D. And again, I told you about this very confusion with respect to patenting of video game and copyright, but I'm talking only about an app. So it is answer is very clear here. It is only copyrightable. Next question: what is the protection period for a patent in India? I'm very happy again. Maximum answers are true. 20 years is the time period for protection in India. The brand name Coca-Cola is a patent, trademark, trade secret design. The brand name. So very specifically, this question was posed to all of you. I'm talking about here. We are talking about the brand name Coca-Cola, not the chemical composition of the Coca-Cola drink. Chemical composition of that very Coca-Cola drink is a trade secret, but the brand name Coca-Cola is a trademark. So again, very happy. 73% student participants have answered it right. Design patent, design right protects. Again, it protects the ornamental on the aesthetic appearance. So aesthetic appearance here is the right answer. Again, most of the answers are right here. Design rights does not protect the functionality. By way of functionality, we mean how it functions. That functionality is covered under the patent law. It does not protect brand name. Brand name is covered under trademark law. It does not protect under internal components. Internal components may be protected under the component may have a functionality, may not have a functionality. So we have to find out what type, what actually we are trying to protect. So, component can be protected under the patent also. So if the answer here is aesthetic appearance, which is the right answer. Yes, over to you, John, sir.
Yes, sir. We are highlighting some of the questions because there were around 60 plus questions that were posted.
All right.
Some of them we answered. Actually, it was related to UGC regulations about plagiarism, which you also have answered. So we have sent the link for the guidelines. So we are highlighting only some of the important questions. I think rest they can mail it to you. One is from Tosif Hussain. If we collect information from across all sources, sciences subject, and develop it into a new form of table with update information, is it come under copyright?
Okay.
It is posted at 11:03 a.m.
Okay, so here we are talking about compilation. Okay, compilations of things which are available in the public domain, of course you can do it, provided that you have the permission to use that very material. Okay, there might be certain statistics which are paid statistics that you cannot use, but if you are using it, of course you can do it. And now the question is whether it will be your copyright. The answer is given under the third test of originality, which I was discussing, skill and judgment test. It says that the analysis will be your. If you do certain analysis of that very compilation, that analysis you can protect. But the content of that very compilation, which is not yours, you won't have any right over it. Yes. Only the analysis part you will be having copyright over, not the main content. Over to you, John, sir.
Okay, sir. The next question is asked by Prerna Sharma. So again, I think it is related to plagiarism, sir. What if I use someone's ideas given in a book as in my review of literature section? Will it also be considered under plagiarism? So it is posted at 11:13 a.m.
Right. See, if we talk about academic honesty, definitely you should always cite whatever you are taking from wherever, because there might be certain concepts which have been developed. For example, I talk about utilitarian theory. I cannot say I have developed utilitarian theory. I can say my understanding of utilitarian theory is this. This is all right, but it is always advisable to cite certain ideas or concepts, whatever you are taking from somewhere. But the main question, whether quoting, using somebody ideas, of course it will amount to plagiarism because that idea is not your own. But if it is a very rudimentary idea, then you need not cite it, because I told you up to 14 characters, if you are using something, it is totally fine. But it is, if it is something unique, which the idea which has been propounded by somebody, then of course it is always advisable to cite it. Over to you, John, sir.
Okay, sir. The next question is actually I'm combining two because both are almost the same. They are, suppose if I am writing a book for CSIR net mathematics, then after that what should I do? And the second question is, if a teacher writes or publish a book, will he will be receiving copyright now, sir? So these are related to book publications.
Okay. Second, okay, so I'll go to the first one. You are writing, I think some MCQs, etc. for net. Yeah, of course you can do that. So you have two options: either to go for self-publication. Second option is either to approach a publisher and ask that publisher to publish it on your behalf. Again, it depends upon what type of contract you have with them. which will determine your royalty. Some may, in self-publication, publisher will say, pay me some minimum rate for 1,000 copies or 100 copies, and you can keep profits whatever you have. You can do that. With respect to the copyright, again, of course, when you write those very MCQs, the copyright will be yours. Okay. Please take note that you should not have copied the MCQs from some other books which are already available. What you can do best is, maybe you can change the words, or you can change the numbers, figures, etc., and create your own. It will help you avoid any copyright infringement claim over it. But and the what was the second question, sir?
It was about if we write a book
Yeah.
for this. So about will they be getting or receiving a copyright if a teacher writes or publishes a
Yes.
book?
So one, I told you there is no need to register your copyright once you write it. For example, this is my notebook. I have written one page on this very notebook. It is my copyright. From the moment it is completed, it is my copyright. I need no protection of it. But because we are dealing with a lot of aspects of commercial nature, it is always advisable to register your copyright. So the answer to your question is yes, you will have the copyright over your book, but you should register it because you are entering into a commercial domain. Your book will be going to the market. It is always advisable, in order to avoid any kind of misappropriation of your book, you should register your copyright.
Okay, so
Over
the
to you.
next question is we'll take, sir, I think we can take only 3 more questions because of time constraints. So rest they can mail it to you. So
Yes.
one is from Tausif Hussain. What if the climatic conditions changes of GI, that is geographical indications, like tea flavor, then will it still remain the same? And trademark if the variations come in mango after 10 years?
Okay. So because when we say, even if it is changing, that change is attributable only to that geographical region only. So the product remains the same, and the geographical region remains the same. So even if certain variations happen, it will remain the same. So no impact will be there on the GI until and unless you are doing mandatorily doing certain kind of modifications, creating hybrids, which you can protect under plant variety.
Okay, so can I pose the next question, sir?
Yes, please. Yes, please.
This is asked by Kanmani. So the question is, my novel's title may be used as a brand name, maybe for a preschool or a toy store. Should I register it now itself? I am halfway through the novel and yet to publish.
Yes, definitely you can register your title of the novel as trademark. You can do that. It is uh, advisable that you be vigilant now and avoid suffering later. You should do that. But with respect to trademark, I'll tell you one thing. If after a few years you have not published your novel, which means if you are not actually using your trademark, you may lose your right over that very trademark. So make sure if you're registering your trademark, you actually publish your novel or use your trademark in some capacity. Over to you, sir.
Okay, the second last question is posted by Rajvi. What does disclaimer with predetermined text mean in regard to trademark? Because it is used generic. Kindly guide.
Okay. So actually, I'm not able to follow this very question.
Sir, actually, it was not much clear. So I think maybe.
Yeah, disclaimer has nothing to do with trademark. Or if you're talking about TM and R word which is mentioned along with trademark, along with a mark. If, for example, Apple, you'll find R in a circle. It means it is a registered trademark. If only TM is mentioned, you are free to use TM with unregistered trademark also. For example, this person was telling that he wants to publish a novel. He can, from today itself, he can start using the title of the novel and use the word TM there. It means that yes, this mark is proposed to be used as a trademark, but it is not registered now. So yeah.
Okay, so the last question, some of them have asked about a person who is having a trademark and has died. So I'll pose the question. I want to know about copyright for the name. For example, a specific king, queen of a famous person who is no more and the name is used an individual brand.
Okay. So two things I'll tell you here. First thing is, names cannot be copyrighted. So here, when the person is saying brand, it means he's talking about trademark. So names, of course, can be trademarked. So if a person has died, okay, and somebody else is using it, so the person who is suing, he has to show that how he has a bona fide interest in that very name. For example, if he is a relative of that very king, queen, whatsoever, so then only he can object to it. Otherwise, he cannot. He has to show some bona fide interest that yes, he will suffer a lot. Or second thing is that he can prove that the use of the king's name is decepting the people, which means the king, people are purchasing that very product by falsely believing that it is created by the family of that very king, whereas it has not been done so. So he can show that there is a remedy available to this under trademark law, that if we show that it is decepting the people, creating false impression in the mind of people, then he can sue. Over, sir.
Okay, thank you, sir. Those participants whose questions have not been answered can contact Sir Sajid Sheikh, sir. He has given his contact details. It is on the screen. And yes, we can conclude the session by vote of thanks. So I request Professor Sandesha Shetty, Vice Principal, Bunts Sangha's S.M.Shetty College, to propose the vote of thanks.
Good afternoon, all. I take this opportunity to propose vote of thanks. First of all, I would like to thank our management for supporting us to organize this webinar. I would like to thank our principal, Dr. Sridhara Shetty, who is the backbone of this national level webinar. Thank you, sir, for monitoring and guiding this webinar. I would like to express my gratitude to Professor Sajid Sheikh, Assistant Professor and Coordinator, Center for Research in IP, Maharashtra National Law University, Mumbai, for your excellent presentation on intellectual property rights. My sincere thanks goes to our IQAC Coordinator and Vice Principal, Dr. Liji Santosh, our IT Head, Dr. Tushar Sambare, our IPR organizing team, teaching and non-teaching staff of our college who have made this webinar a grand success. Finally, the wonderful participants who have turned up in such great numbers from different parts of India. Thank you so much for your cooperation. Thank you one and all for your present here. Thank you.
Thank you so much, everyone.
Okay, sir. Can we conclude the sessions then? If anyone from the team wants to say anything, or we can conclude.
Okay, so all the participants, we are going to send you the link of feedback. that everybody has to submit. The feedback will be shared in Telegram group, our official Telegram group for this seminar, and also we are going to send the link through email. After successful submission of feedback, within few days we are going to mail you the certificates of seminar.
Thank you, everyone.
Thank you,
The
sir.
principal sir
Thank
wants
you.
to.
Thank you.
Okay.
Okay,
Can I
sir.
speak? Can I speak?
Yes, sir. Yes,
Yes, sir.
sir.
Yes,
Want
sir.
to say anything?
Yeah. Advocate Shadi Sheikh, it is really a great and wonderful session, sir. And the best testimony is the appreciation we have received by participants. It is really a marathon session for nearly 3 hours. Still, people have the energy to ask the questions. It signifies the content you have delivered. It's really wonderful. And one more thing, what I observed is that, sir, in a very lucid style, you are delivering the things. Subject is complex. With the examples and all that, you made it very familiar. So therefore, we are highly thankful. And once again, I thank you profusely for this kind of delivery. And we are looking forward to you in the days to come also, because this is an important area. So on behalf of the institution, once again, I thank you profusely to all the participants and my team from the background done exceedingly well. Thank you very much.
Thank you, sir.
Thank you so much,
Thank you,
sir,
sir.
for the appreciation. I really appreciate, that amongst this very time, your team has, managed to, conduct such a very useful webinar for your students. Some of us, we think, okay, lockdown is there, so it is the time for us to relax. But of course, the best use of this very opportunity, has been done by your team. I thank each and every one from your team, also the participants who are here with us today. So hope for more and more similar sessions. Thank you so much.
Thank you so much, sir. Thank you.
Thank you, sir.
Thank you all.
Yeah.
Officially concluding and ending the seminar.
Okay.
Okay, sir.